Go ahead, counsel.
Thank you, Your Honor. Just a couple more questions. At some point, did you learn that the Arvizos had divorced?
No, not until recently.
Okay, and was it your understanding that Janet had applied for welfare?
I didn't know that.
And did you ever learn that she applied for disability?
No.
And you never knew she'd obtained a big settlement of any kind?
I'm going to object as asked and answered. Irrelevant.
Sustained.
Okay, when did you last see the Arvizos?
Let's see, probably in the hospital. I don't really recall.
Okay, did the visit to your home happen after Gavin was in the hospital or in the middle?
Kind of in the middle. His treatment was like a year long.
Okay, and do you remember the last time you talked to Janet?
In the hospital.
Okay, not at your home?
No.
Okay, now, obviously you learned about your husband's strong disagreement with David, correct?
Uh-huh.
You knew that David was calling the radio station, correct?
Yes.
And at some point you basically severed all ties with the Arvizo family, correct?
Yes.
And did you ever see them after that?
No.
Ever talk to them after that?
No.
Okay, now, did you ever discuss any fundraising plans with anyone else at the Laugh Factory?
No. We were going to do the fundraiser at the ice house.
Okay, did you ever get involved in any efforts with the Laugh Factory to have a fundraiser?
I still don't remember that fundraiser.
Did you ever talk to Fritz Coleman about a fundraiser for Gavin?
No.
Okay, and you were planning the one in Pasadena, correct?
Yes.
And were you planning it mostly with David?
No, myself.
Okay, were you talking to the children at all about that?
No.
About whatever role they would play in it?
No.
Okay, and did you get to the point where you were actually doing invitations?
No. We were going to announce it on the radio. The way it works is, usually the way we were going to do this one was George was going to announce it on the radio station, and then, the price and the time, and then the laugh. I'm sorry. The ice house was going to take the reservations.
How? Did you ever know at any time whether or not Fritz Coleman had made announcements about another fundraiser for the Arvizos?
Yes, I think there was a fundraiser, but we weren't involved in that one.
You didn't communicate with anybody about that?
No.
So yours was separate and apart from anything that the Laugh Factory was having?
Yes.
Okay, no further questions.
Redirect.
Ms. Lopez, you said that you thought that Janet's gratitude was spiritual. What did you mean by that?
Well, she said she was praying for us and thanking us for being with Gavin, and for giving him comfort and giving him hope and making him stronger spiritually by being at his bedside.
Did she ever say anything to you about money that had been given to David by your husband?
No.
Did she ever say anything at all about any of the gifts to the family at all?
No.
Did she ever talk to you about that gift that she gave to your husband, the keychain?
I thanked her for it, because it meant a lot to George.
Could you describe the gift for us?
It's a small keychain. It has a mustard seed in it, and she said that she had it for. It was obviously used, and that she'd had it for a long time and she just wanted him to have it.
And he accepted it?
Yes, he did.
And was grateful for it?
Yes.
You made the statement that you thought the kids were a tool for David, or something like that.
I'm sorry?
Were a tool of David?
Yes.
Tell me what you meant.
Well, it just seemed he didn't have a connection with his children. And to me, it seemed like he was using Gavin's illness for gain, financial gain.
Did you notice any change in David's behavior as the months went by while Gavin was in the hospital receiving treatment?
Well, he just kept asking for money. I mean, it was just kind of his MO.
It was consistent?
Consistent.
Every time you were there?
Yes.
I have no further questions.
No further questions, Your Honor.
Thank you. You may step down.
Your Honor, we'll be recalling Sergeant Bob Spinner.
All right.
And I would ask permission to reopen my direct. I think my near-fatal accident on Friday jarred my thinking process. I was traumatized.
You may be seated. You're still under oath. Did you discuss that with counsel, so they know why you've asked me to do that?
I don't know why. I was just informed he wanted to do it.
I did tell Mr. Sanger this morning at the same time that we talked about calling Mr. Lopez out of order, perhaps.
Would you tell him so he knows? I just want you to know in case you're...
I don't know. Could we have a moment so I can find out?
Yes. Please do. Off-the-record discussion held at counsel table.
If the question is, do I now know I have the general subject matter, and I have no ability to form an opinion as to whether or not it's appropriate to reopen based on what I was just told?
All right. Go ahead.
Thank you, Your Honor. Detective Spinner, on Friday, you mentioned a series of 19 fingerprints that you made positive identifications on. I'd like to talk to you specifically about the items that are marked in the 317 series of sheriff's evidence that you testified you had made identifications on. When you examined those items in the 317 series, did all the items that you identified fingerprints on arrive at the same time?
No, they did not.
Would you explain that for the jury, please?
When I was first assigned the job, I went to the property room to obtain items 306 and 317, which were the two initial item numbers. I was told, when I got item 306, that 317 was not available, and it would be available at a later date. I was advised on August 3 that the 317 that had been, or part of 317, which had been at the DOJ for laboratory for analysis, was back, and I went out and got it. I was later advised that there were a number. The remainder of 317 was brought to the forensics lab. When I came back to work on October 5, it was locked in the cabinet in the forensics lab and the remainder was in the black briefcase.
So you got one portion of it in August?
Yes, sir.
May I approach the witness, Your Honor?
Yes.
Marked as 622.
Your Honor, I am going to object that this is not proper to reopen. It's basically material that's covered, and it's elaboration on something that he brought up in redirect.
May we approach, Your Honor, so we do not?
No. I've already given you permission to reopen. Proceed.
Thank you. I've placed in front of you Exhibit 622. Is that 622?
Yes, sir, it is.
Okay. May I use your copy, please?
Okay.
I'm just going to hold it up. It appears to be nothing more than a couple of timelines, correct?
I suppose that's not appropriate to publish it until it's an exhibit.
There's really nothing on this.
There is something on it.
Counsel, you're required.
It is just a couple of timelines.
Counsel, you're required to mark the exhibit, show it to opposing counsel, and then show it to the witness without publishing.
I understand. I apologize, Judge. What is on 622?
It appears to be two timelines for the year 2004, and one for a brown evidence bag, 529, and for a black briefcase, 470.
Okay. Do you recognize Exhibit 470?
Yes, I do.
And do you recognize Exhibit 529?
Yes, I do.
Beginning with Exhibit 529, can you please open the package up, and how do you recognize that exhibit?
This is the evidence bag which I received the first grouping of items which were booked into evidence under Sheriff's Evidence Item number 31-7, or 317.
Okay. On Exhibit 622, can you please note on the timeline?
Do you want me to write that down?
Please write the date that you first opened that bag on the timeline, and on which date.
Has that timeline been marked as an exhibit?
It's Exhibit 622, Your Honor.
Is that Exhibit 622?
Yes.
Go ahead.
Tell the jury what you just wrote.
8-3 of 04.
And that's Exhibit number 529?
Yes, sir.
Okay. Can you tell the jury, please, which items from Exhibit 529 were items that you were later able to make positive identifications of fingerprints in?
It would have been 317, L, Lincoln, 317R, Robert, 317S, Sam, and 317Y, or Yellow Yellow.
Do you have a list of the names of those publications?
Yes, I do.
Okay. Can we start again, please, with the 317L with a name?
317L is December 2000 issue of a magazine entitled, Finally Legal.
Okay. And whose fingerprints were in that magazine?
Star Arvizo.
Was there another magazine that was in 529 that you made positive identifications of fingerprints out of?
Excuse me for 1 minute. 317R, Robert.
And the name of that magazine, please?
Is Hustlers, Barely Legal Hardcore.
Could you tell the jury which fingerprints you were able to positively identify in that item, please?
3 fingerprints from Gavin Arvizo, and 1 fingerprint from Mr. Jackson.
Just for the record, is 317L, You're Too Fast, Exhibit 513?
Yes, sir, it is.
And for the record, is 317R Exhibit 518?
Yes, it is.
You mentioned a couple of other publications?
317S, Sam, which was an unknown date issue of Penthouse magazine with the cover removed.
For the record, is that Exhibit 519?
Yes, it is.
Was there another publication that you recovered positive fingerprints from which were contained in Exhibit 529?
317Y, Yellow Yellow.
And that was?
The name of that was Al Goldstein's 100 Best Adult Videos.
And whose fingerprints did you recover in that?
Gavin Arvizo.
And does that appear to be exhibit number 504?
Yes, it does.
I'll let you package that up before I ask some more questions, okay? Don't put that away yet. Are each of the publications that you have just described for the jury marked on the front of exhibit number 529?
Yes, they are.
Okay. Are there additional items denoted by 317 followed by a letter of the alphabet written on exhibit 529? You don't have to read the list.
Yes, there are.
And at the time that you received exhibit 529, did you conduct an inventory of what was inside the bag compared to what was written on the exterior of the bag?
Yes, I did.
Did you find any item missing?
No.
Okay. Did you find any item inside the bag that was not accounted for on the outside of the bag by item number?
No, I did not.
Okay. Could you tell the jury, please, what date you began processing exhibit number 317L? And, processing, I mean the procedure that you described for us on Friday.
Okay. I obtained the items on 8 to 3 and we started the processing on 8 to 11.
Could you mark that, please, on your exhibit 622? Is it legible?
Yes, sir.
Are you using a pen now?
Yes, sir.
Okay. With respect to exhibit 317R, item 317R, the exhibit number 518, could you tell the jury, please, when you began processing that item?
The same day, 8 to 11, August 11th.
Would you please put that on the timeline as well? Does the same hold true for items 317S, Exhibit 519, and 317Y, Exhibit 504?
Number 317, Sam, and 317Y were started on 8 to 12.
On August 12.
Yes.
Of 2004? Could you put those two items on the timeline as well with the date that you began processing them, please? Just remember we'll have to read that later.
You've seen my writing.
You mentioned that you did not have Exhibit 470, the black briefcase, at the time that you had Exhibit 529?
That's correct.
When were you able to take custody of the black briefcase, Exhibit 470, and check through the contents?
On 10 to 5 of 04.
On October 5 of 2004?
Correct.
Do you know where the briefcase had been prior to that time?
I was told it had been.
Calls for hearsay. Objection.
Sustained.
Do you want to look at the briefcase now or do you need to?
No, I don't need to. It's got seals on it.
Okay. Did you find fingerprints for which you made a positive identification on any publications that you removed from Exhibit 470, the black briefcase?
Yes, on 3.
Could you please tell the jury on which magazines those were, publications, I mean?
317 Ocean, O, which was, it was a barely legal magazine. 317 T, Tom, which was a Visions of Fantasy, a hard rock affair magazine. And 317 Union, which was a Visions of Fantasy, Jose's Black Starlet magazine.
Okay. Beginning with Exhibit 515, Item 317-0. Whose prints did you find in that again?
It was Mr. Jackson's.
And Item 317T, Exhibit 520?
Mr. Jackson's.
And Item 317U, which is Exhibit 521?
Would have been Gavin Arvizo.
And on which page of that publication was that print located?
Your Honor, this is cumulative. It's been asked and answered.
Page.
Yeah. What is it that you didn't do last week that you're doing now?
Just this last part of the timeline, Judge. Didn't ask him any questions about dates of processing, or when he received the material.
Well, let's limit it to the dates, then, and not go through the rep. Whose prints are on what? You covered all that last week.
With respect to those three items, what date did you process them, if they were all on the same day?
On 317-0, I started processing on October the 5th, and it was completed on October the 12th.
Okay. Could you please put that on the timeline? How about Exhibit 520, 317T?
On 317T, again obtained on October 5th, and completed on October 12th.
Can you please write that on the timeline as well, Exhibit 622? And how about Exhibit 521, Exhibit 317, Item 317U?
317U, again initially obtained on 10, or October the 5th, and it was completed on October the 12th.
And could you write that on the timeline as well? At this time, Your Honor, I'd move 622 into evidence and request permission to publish.
Before the court rules, could I take a look at it, please?
Yes.
May I approach to do that?
Yes, you may.
Would you mind bringing it back, if you're amenable?
Counsel's asked me to bring it back, so if that's all right, I'll do that.
Save me a trip. Laughter. A trip.
It's on.
It's on?
It should have been, unless somebody turned it off.
What input do you need?
I believe that is input 4, Your Honor. The Elmo. Does Exhibit 622, does that exhibit accurately reflect the items of evidence you were able to find identifiable fingerprints from and the dates that you processed them?
Yes, sir.
And it also accounts for the items of evidence from which those publications came from?
Yes, sir.
Did you process any magazine or periodicals that came to you for fingerprint comparison in the month of September that you recall?
I was gone for at least 3 weeks in September on a trip, and I don't believe I did much processing of anything in September. I might have done something at the tail end of September, but I can't recall.
Okay. Generally, what was the success ratio in checking for fingerprints in these magazines, periodicals?
Objection. First of all, the question is vague as to which set of magazines. But secondly, that's cumulative. The overall question has been asked and answered with specific numbers.
I'm not sure that has, Your Honor.
I don't know what you mean by success ratio. I think we covered that last week.
Okay.
But I don't know what you mean by that, so I'll sustain a foundation objection.
Regarding your ability to locate latent prints on the kinds of materials that are in front of you, the 317 series, if you can explain in a percentage, only if you can, please describe for the court what kind of percentage ratio you can successfully find latent prints on these kinds of items, if you know.
Objection. Foundation. And it's unintelligible.
Sustained on foundation.
Why don't we move on? Were you concerned about contamination of the fingerprints in this case?
Objection. Your Honor. This is beyond the offer to reopen.
Sustained.
I have no further questions, Your Honor.
622's admitted.
Thank you, Your Honor. Do you need those exhibits or?
Just leave them. That's fine. May I proceed, Your Honor?
Yes.
Sergeant Spinner, how are you?
I'm fine, sir.
Good. And you're retired?
Yes, sir, I think so.
Okay. Not for a little while anyway. First of all, when you answer the district attorney's questions as to whose fingerprints are on something, that's your opinion. Is that correct?
That's correct.
And fingerprint identification is subjective. Is that right?
It falls into two categories. The initial examination and evaluation, I would say, is based in fact. The opinion is subjective.
Alright, so ultimately your opinion. This is what I was asking, I believe. Ultimately your opinion as to whose fingerprints match is a subjective opinion, correct?
That would be correct.
Alright, now, you indicated, in this last bit of testimony this afternoon, you indicated that, in essence, you received materials with regard to item number 317 from two different locations, right?
2 different times.
Well, okay, 2 different times. They were from 2 different bags, right?
That's correct, sir.
Alright, one bag you told us about there was Exhibit 529, which was an evidence bag, right?
That's correct.
And the other was the briefcase, which was actually 470, Exhibit 470, court exhibit.
Yes, sir.
And within 470 were a group of magazines, correct?
Among other items, yes, sir.
And some loose pages as well?
That's correct.
And those materials were simply in the briefcase, right?
Correct.
They were not separately put into plastic bags or envelopes or anything else, is that right?
Not till I got a hold of it, yes, sir.
I'm talking about when you received it. Those items were not put into separate evidence containers, whether it be a plastic bag, a paper bag or some other form, correct?
That's correct.
Now, you located ultimately 19 fingerprints that you've talked to the jury about, and we have the comparison boards there. Is that correct? That's the right number?
That's correct.
10 of the prints, including at least one that you attribute to Gavin Arvizo, came from items other than the bag, 529, that you believe came from the Department of Justice. Is that correct?
I haven't totaled it up, but, yeah, I'll take your word for it.
I don't want you to take my word for it. Is that approximately correct? Or you can total it up, if you'd like.
It would be approximately correct, yes, sir.
Alright, and at least one of the prints from Gavin Arvizo came from something other than evidence bag 529. Is that correct?
Correct.
Objection. Misstates the evidence, Your Honor. The evidence is one, not at least one.
Objection. Speaking objections.
Sustained. The objections overruled.
Is that correct, sir? Is that correct? He may have answered. I don't know if the answer came in.
He said, correct.
Okay, thank you. Now, there were also 2 other prints that had been identified either as positive or inconclusive, and those 2 were switched or shifted at a date after your initial reports were written. Is that correct?
Yes, sir. After a review by a third party, yes, sir. That's correct.
Let's talk about those 2 for a moment. You wrote final reports on the various latent print examinations that you did on a certain date in December. Is that correct?
As the item process, each item was finished, I had a mandate to complete a report within 24 hours of completing each item as I went, so it would, when the report was written, would depend on when the total completion date on that item was, actually happened.
I'm sorry.
Go ahead.
What I'm asking, and maybe I wasn't clear, as of December of 2004, you had final reports written on your identification of the various prints. Is that correct?
December the 17th, yes, sir.
Alright, and then these 2 prints were subject to additional reports that you wrote sometime in 2005. Is that correct?
Yes, sir, that's correct. That was due to an agreement that
I'm going to move to strike as non-responsive.
Okay, that's correct, sir.
Stricken.
Thank you. One of the prints had been labeled as inconclusive as of December 2004. Is that correct?
That's correct.
And then in January of 2005, you wrote a report indicating that you believed that that should be positive as to Star Arvizo. Is that correct?
Yes, sir, that's correct.
The other print had been written up, as of December 2004, as inconclusive. I'm sorry, as positive as to Mr. Jackson, and then you changed that to inconclusive. Is that correct?
That's correct.
And that was based on additional consultation that you had?
Yes, with Mrs. Hemman and also ID Tech Allmeyer of the Santa Barbara Police Department.
And ID Tech Allmeyer is somebody that you've known for a number of years, is that correct?
Yes, sir, it is.
And he worked for the sheriff's department for quite some time?
I'm going to guess about 4 years before he went to another job.
So that was not a stranger who you called upon to do a review of the work, is that correct?
No, but I trust his judgment.
Alright, now, you indicated last week that you had examined about 80,000 prints in your career as a latent print examiner, is that correct?
That's an approximation, yes, sir.
21,000 of them were in this case, correct?
Approximately, yes, sir, probably close to that.
See, over 1/4 of your experience in comparing latent prints in cases occurred in the Michael Jackson investigation. Is that correct?
It may be, 80,000 may be slightly low. It could be. It's, to say the examination I've done just in this case alone as 1/4 of my total experience I don't think is true.
Okay, so you want to revise the number upward from 80,000?
I would say it would be in maybe the 100 to 120 figure. Probably not much more than that.
Okay, so a fifth. If those figures are correct, a fifth to a sixth of the prints that you've examined in your career have been in Mr. Jackson's case. Is that correct?
That may be close, yes, sir. It was a large amount that we did all at once.
Alright, now, you found 706 latent prints in this case that, when I say, you found, let me withdraw that. The people in the unit who you were working with ultimately found 706 latent prints.
That's the number we were sent, yes, sir.
Okay, so when you say, sent, there were people in the Santa Barbara unit and there were people in the Santa Maria unit that were sending you prints?
They were providing us prints to examine, yes, sir.
Alright, so 706 of them, right?
Correct. At my count, yes.
And you matched up 20 or so?
There were 19 positive IDs out of that amount, yes.
19 as you testify today, but you had another positive ID that you changed back to inconclusive. Is that correct?
Yes, sir, it is.
That's why I say 20.
Yes, sir, 20.
Of the 706 prints, there were 178 that you believe were sufficient to make a match if you had something to match it to. Is that correct?
That's correct. Part of those were palm prints, and they weren't all fingerprints. I believe there was 13 palms mixed in that number.
Okay.
If my memory serves me correctly.
Alright, so 165 fingerprints and 13 palm prints?
It sounds close, yes.
You were asked to compare these fingerprints only, and palm prints, for that matter, only to the prints that were presented to you for Mr. Jackson and for Gavin Arvizo and for Star Arvizo. Is that correct?
Yes, we had a complete set of fingerprints for Gavin and Star Arvizo, but I only had exemplar fingerprints for Mr. Jackson.
I'm sorry. Say that. What did you say?
I had no palm prints for Mr. Jackson.
I see. So you just had fingerprints for Mr. Jackson?
That's correct.
Alright, now, let me walk in between everybody here. Excuse me. May I approach, Your Honor? I'm sorry.
Yes.
Let me show you 743, 744 and 745. And I believe that you had already said on direct examination that those are, in essence, blow-ups of the other prints that are in evidence. Is that correct?
That's correct, sir.
Now, 2 of those are rolled prints, inked prints. Is that correct?
Yes, sir.
And 1 is the live scan, which is a digital film. I don't want to say digital film, but a digital representation of the prints. Is that correct?
That's correct.
And how many sets of fingerprints did you have for Star and Gavin Arvizo to work from?
We had 2 sets of each.
Okay, now, for some reason you've just shown us, or let me withdraw that. The prosecutor has shown you and you have identified 1 set of prints for each one, correct?
Objection. Misstates the actual exhibit boards. I'd like counsel to be specific here, or it's vague.
Just a moment. The objection's overruled.
Do you have both sets of rolled prints on each exhibit there?
1 set of prints for Star Arvizo has 2 cards on it, and the one for Gavin Arvizo has 1.
Okay. Was there another set of rolled prints for Gavin Arvizo that you're aware of?
Yes, but if my memory serves me correct, they were not. They really weren't any good.
And so you had those redone? Did you have those redone?
They were redone at my request, yes, sir.
Did you also have Star Arvizo's prints redone?
Yes, sir.
And you wanted to see if a better set of prints could be developed?
That's correct, sir.
Did you believe at the time you looked at it that Mr. Jackson's prints were done appropriately?
They could have been done better, but they're appropriate, yes.
Okay. And the same, well, let me withdraw that. As far as Star Arvizo's, his first set was done appropriately but could have been better. Would that be your testimony?
His first set was okay, but they could have been better. As I recall, there was some smearing in areas that really couldn't be seen into as far as the clarity.
Okay. Now, we're talking about the known prints or the rolled prints, as they're usually called, of the particular subjects, right?
Yes, sir.
Okay. And one of them being LiveScan. But what do you refer to them all as collectively? Known prints?
I call them exemplar prints.
Exemplar prints, alright. And the idea is that if you do not have a good example in your exemplar prints, it makes it more difficult to determine whether or not a print, a latent print, is identifiable. Is that correct?
You have to have, yes, sir, it is. You have to have the same clarity to be able to see the detail in the known print that you have identified in the latent print.
What sorts of things can cause known prints or exemplar prints to be imperfect?
Deposition pressure, torquing. When the print's rolled, sometimes the tip will roll faster than the base and you'll get some smearing going on.
Imperfections in the paper?
Normally imperfections in the paper. That the cardstock that's used is what's supplied by the state or the FBI, and it's pretty common, standard, and we don't get that much problem. It's a hard cardboard type paper and it doesn't twist or bend.
It doesn't twist or bend, but occasionally something will not show up on the print.
There might be an area that's blank. That would be deposition pressure.
So in other words, there wasn't enough pressure put on the finger to apply it to the cardboard in order to transfer the ink?
That could be. Or it wasn't inked properly, if ink was used.
Okay, so the finger was not inked properly. Therefore, there was not ink on that part of the finger to make the imprint on the paper, correct?
That's a loose definition, yes.
Okay, well, I don't want to be too loose. Is that close enough?
Or there was a blank spot, or there was a bubble, or there was some other reason why there was not a total recording of the friction ridge skin.
You talk about torquing. Is that turning the fingers so there's a smudge or a smear or a distortion?
Yes, sir.
Alright. Are there any other, in rolled ink prints, are there any other causes that you're aware of deformation in the print?
Well, you could have too much pressure also, which will cause the ridges to be wider when they wouldn't normally be, or they will normally either hide some detail because the ridge is flattened out.
Too much ink might just cause a blot?
Too much ink might just cause some pressure, yes.
Now, what about the LiveScan prints that you have of Mr. Jackson? Can you tell me what deficiencies there are in those particular prints?
They're a little scattered, possibly because his hands were dry when they were rolled.
So not all of the detail was actually transferred to the digital format, is that correct?
Not all of it in some areas, like below the base of the thumb, shows up, and why it's not there I don't want to hazard a guess.
Okay, so in other words, there should be more there. If it was done properly, there would be more of a print, more ridge detail?
It would depend on, again, how the prints were rolled and who did it, and how much care was taken, etc., with the LiveScan, because you're not actually using ink. You're relying on moisture, a glass platen, which is then read by the machine to record the prints.
Would you agree, based on your experience, that properly rolled ink prints are a better exemplar than LiveScan?
Correct.
LiveScan, however, is used because it's more convenient, is that correct?
I don't know that convenience would be the proper word, but it's an overall method to get the fingerprints transferred back and forth, since it's just a digital, for the Department of Justice purposes rather than mailing inked cards.
It's a little hard to hear. It's the end of the day, and I think you're trailing off.
I'll move closer.
In other words, LiveScan is simply a way to get it directly into a computer system so you can make a disk or send it by email, you can send it off to the DOJ, to the FBI, correct?
Yes, sir, it's a quicker way of getting a set of rolled fingerprints for identification.
One of the reasons it's good to have rolled. We're going back to rolled, which I kind of like. You said exemplar prints, so let's stick with that. We covered live scanned and inked prints, right?
Yes, sir. That's correct.
So it's important to have a good set of exemplar prints so that you can look, as an examiner, to see if ridge detail matches ridge detail from the latent print to the exemplar print, correct?
That's correct.
You also need to look at the exemplar print, when comparing it to the latent print, in order to determine if there are any unexplained differences between the two. Is that correct?
Well, you compare the two, latent to known, known to latent, and then you have to work out the discrepancies between the two, yes.
All right.
Counsel, I'd like to stop a little early, because there's a couple issues we need to take up outside the presence of the jury.
Yes, sir.
I'm going to excuse you now. We'll see you at 8:30 tomorrow morning. And remember, Thursday you won't come in. We need that door closed back there.
I'll get it.
He took care of it, sir.
Let's see. The first issue I wanted to take up was the question of whether or not we should instruct the jury on the 1108 and perhaps 1101 evidence before, at the time of taking the evidence, during, after. I like to instruct juries on special points as we go along. I don't know when you intend to start your 1108 evidence, now that the ruling's been made. And you don't need to. Since I'm just putting that to you right now, you don't need to answer me now. I'd like to know tomorrow. And if you have a suggested instruction, I think there might be a CALJIC that applies. I haven't looked. Anyway.
Yes, I believe they should be pre-instructed. And yes, there is a CALJIC that's been approved by the courts to be given in such situations.
All right.
And I would anticipate maybe in 2 weeks, depending on the length of cross-examination of certain witnesses.
So that gives everybody time if you want to submit a different instruction or a pinpoint instruction or...
We'd want to do that, Your Honor. There is some, for example, burden of proof we think should wait till the end, but there are some pre-instructions we would like on that issue.
I just put you on notice so you can start feeding me information. That gives me. I can relax a little bit, because I know we have time to do this right.
Thank you.
The second issue is one of the witnesses who's testified, Kiki Fournier, has called my secretary. And as I understand from my secretary, has contacted both attorneys and she has requested permission to travel outside the United States with her child, or children, I don't know. And she advised my secretary that she could not get agreement from the attorneys on her ability to do that. She's willing to be on a return call for 48 hours if someone needs her. So I need to get your position. I think she's basically testified and been cross-examined. I don't think she's been excused technically. But I don't like to prevent people from going on with their lives when we can make arrangements to allow them to go on with their lives and still be available when they're needed. What's...
Judge, I indicated that was more than okay with me, that she could go. I anticipated that if we would want to recall her, we would still have time, because we probably would not have rested by the date she plans on returning, so therefore it shouldn't be a concern in terms of the defense calling her, because she would be available if they wanted to. So as far as I'm concerned, she could do that. If an emergency arose, and we need her to come back, it sounds like she's willing to come back and we would arrange that. So as far as I'm concerned, she can go and should go.
Your Honor, I don't want to interfere with her travel plans at all. Our concern is there is a great likelihood we will recall her for a lot of reasons I don't want to disclose at the present.
Nor do you need to.
It seems to me that her plans, I don't know where she's going or when she plans to leave. But her plans are to be back in the near future, is that correct?
Within 28 days, I think. And I think she plans to leave immediately. You probably know more than I do. My secretary just said we have a problem here, and
I can assist the court and Mr. Mesereau in this regard, Your Honor. My information is she needed to book the tickets today. She was going to leave immediately and she'd be back the first week in May.
So that's more than the estimated time I thought. But at any rate, if you're not going to put on your 1108 evidence for 2 more weeks, I can see that. It seems to me that's a safe return date for her.
Yeah.
Okay.
Again, I don't want to interfere with her plans.
I would require that she sign a statement like, "She's on subpoena," and it's not uncommon. In fact, it's more common than not that we put these people on call, under an agreement, and the code section provides for that. And I would have her sign an agreement to return upon 48 hours notice if there was an emergency before her return date. And then I would personally go to Europe and get her if she.
We will agree to that, Your Honor.
All right, even if it took me months to find her. Laughter. I think it's the right thing to do, so I appreciate that. I'll take care of that. Then I think we're through for the day. Thank you, everyone. I'll see you tomorrow at 8:30.